Hello everybody, I'm Pouyan Darian, back again, talking to you about immigration law. So as many of you already know, I only practice immigration law all day, every day, and I handle cases all over the United States. So what I want to talk to you about today is applying for citizenship, naturalization. Now, a lot of my videos are specifically about obtaining permanent residence in the United States, and specifically obtaining permanent residence through a U.S. citizen spouse. But what happens next? What do you do from there? Okay, so I'm going to talk about two separate routes through which a permanent resident becomes a U.S. citizen in the United States. The first one is for somebody who became a permanent resident through a U.S. citizen spouse, and they are still living with that spouse and still in a good faith relationship. Now, typically speaking, if you married and you apply for permanent residence and you become a permanent resident within 2 years of marriage, your permanent residence is conditional. 2 years after you become a conditional resident, well, actually a few months before that deadline, you have to apply to remove the conditions on your residence. And then it could be a while before your actual full permanent residence is issued and your conditions are removed. Now, something that many people don't realize is even while that's pending, they could still apply for citizenship once the 3-year mark hits from the date you became a conditional resident. So what that means is you go for your green card interview at the beginning of the process with your spouse, you get your conditional permanent resident card, your green card in the mail. It's got an expiration date 2 years down the road, but it also says the issue date, the date on which you became a permanent resident. Calculate 3 years from that date and you can apply for citizenship. Now, there are some conditions, as I mentioned earlier. You must be living with the same U.S. citizen spouse, and you have to actually submit continued evidence of your good faith relationship to apply under this 3-year citizenship provision. So regardless of how you obtained your permanent residence, whether it was through asylum or an employer or a family member, you can apply for citizenship after the 5-year provision without submitting any other evidence other than a copy of the front and back of your green card, the filing fee, and the application. It's that simple if your case is that straightforward. This is where a little bit of the complexity comes in. There are other requirements. First off, there's a good moral character requirement. You must have been a person of good moral character for 5 years preceding the date you apply for naturalization. That could be something as simple as not applying for selective service if you're a male in the United States under the age of 26 when you were here. It could be that simple. It could be a whole slew or a series of criminal convictions that were pretty minor, but taken as a whole, they show a history of non-compliance with the law. It's really discretionary to an extent, and the officers have a lot of wiggle room to deny an application on discretion based on a failure to demonstrate good moral character. Now, actual criminal convictions, you should definitely speak with an attorney about, because sometimes it's as simple as just waiting 5 years from when the last conviction took place. Sometimes it's substantially more complicated. And you definitely want to get all of the records pertaining to any police contact. That's a really tricky issue, and you should not do this by yourself if you have anything like that going on in your case. Okay, the second thing that I really want to discuss as a substantive requirement is continuous residence in the United States. And there's also something, physical presence requirements. So these two requirements are often conflated and confused. Basically, to summarize them, you should not have a departure that exceeds 180 days within the 3 or 5 year period that you're trying to establish before citizenship. Any break Any 181 or longer day trip essentially restarts the time period because you've broken continuous presence in the US. And the other requirement is you must have spent 51% of those 3 or 5 years in the US. So for the 5-year citizenship provision, you must have spent more than 30 months of the preceding 60 months, 5 years in the US. That's exactly what it says in the USCIS policy manual for adjudicators, for the people who are reviewing your application. Any person who has not met these requirements will almost certainly be denied, and they'll lose their application filing fee. When you apply for citizenship, your entire future in the United States is at stake. The officers will review everything from the very first visa application until now, because once you become a citizen, it is very difficult to lose that status, although it's technically possible through something called denaturalization. I've never personally seen it happen, but I've researched it and heard of it happening. What is much more common and a terrifying scenario is where someone who's been a permanent resident for 20 years applies for citizenship, and something that oftentimes a mistake that USCIS made 20 years ago now pops up. Like, I've specifically seen an applicant for citizenship who was in all respects eligible. He went for his examination after he applied for citizenship. He passed his English and civics exam, and he received the certificate saying, "You've passed, wait for a notice." Time passes, a few months, 6 months. Now it's been 9 months. I asked USCIS what's going on. We eventually get a notice placing him in deportation proceedings. So this is a permanent resident who's been here for 20 years, finally pulls the trigger to apply for citizenship, and boom, he's placed into deportation proceedings. Literally the nightmare scenario. Ultimately, we were able to fix the situation, but in this case, it was because 20 years ago, he had forgotten to file an I-751 petition to remove the conditions on his residence, and instead, he filed an I-90 application to renew his green card, and USCIS mistakenly approved it and kept granting them for 20 years. No one knew, and the only way we could have figured that out was through a Freedom of Information Act request. So it's an important thing that I'm going to discuss in a separate video. So if you found some of the content in this video to be complex, at least download the N400 application off the USCIS website. What I was really trying to do in this video was illuminate some of the really complex framework of law that is behind some of the seemingly complex questions on the N400 application. Because when you look at it, it may seem really straightforward, but upon second glance, when you've been dealing with these day in and day out, it can be a lot more complex than you think. So remember, I'm Pouyan Darian. I'm an immigration attorney who handles these issues nationwide. If you want to schedule a consultation to discuss the particular facts of your life and see what the best issues, whether you want to apply for permanent residence or citizenship or some other immigration benefit, give us a call or text me at 914-885-3961. I'd be happy to discuss your issues, and please stay safe.